Hello, my name's Dr. Fiona Kumari Campbell. I'm from the School of Education and Social Work at the University of Dundee in Scotland. And today I'm going to speak with you on the subject of human rights. Can they be taken away? I've got a bit to cover, so I will move through, my talk fairly rapidly. So let's firstly start with a question. One of the questions that we might want to look at when we're thinking about whether human rights can be taken away or in fact whether they exist at all is to ask, what is rendered invisible when we approach our thinking through a human rights lens? In other words, we might want to ask ourselves what forms of violence or inequality cannot be viewed as violations of human rights. So this raises some fairly complex political and philosophical issues about the way in which we frame notions of justice. What happens when we frame notions of justice in the language of human rights. Now, if we do that, certain assumptions are implied. In other words, the assumptions are, well, what constitutes injustice? And how do we vanquish injustice? So, in many ways, notions of justice are framed by its constitutive outside injustice. So, one of the consequences then of this issue is when we're talking about human rights, we're talking about law coming in and recognising certain forms of discrimination. In other words, certain forms of discrimination are deemed to be illegal at law. So one of the consequences is that many groups and many marginal communities are faced with the prospect of lining up to get recognition of their rights, either in the form of as a protected class, as in some jurisdictions, or having recognition of a particular attribute in law. And in fact, we can probably argue, and I certainly would argue, that law often has great difficulty recognising and responding to the marginality experience and explanations of groups, the reality that groups face beyond an individual rights approach. We'll come back to those aspects later. But we might also want to think about what other erasures happen in law. I've talked about the issue of the question of how we understand the notion of injustice. I guess that raises that kind of bigger issue about what harms are recognised in law. What harms are recognised as being heinous. And Wendy Brown raised this issue many years ago, that a human rights paradigm often requires us to posture to formulate rights in the form of rights as suffering. In other words, groups, in approaching the law, getting recognition of their claims of discrimination, their claims of marginality, have to show that individually and as a group that there has been suffering. So it kind of locks then kind of social inclusion into a paradigm of suffering, and with all the baggage that's associated with that. There might be other harms, for example, that have great difficulty in being recognised in law, but both at a practical and conceptual level. If you think about the notion of ableism, for example, and how it impacts on the lives of disabled people and people with non-normative bodies, there is limited discursive recognition of not just the existence of ableism, but the operation of ableism on a day-to-day basis. But I'm getting ahead of myself here, so I thought we'd strip it back to basics here, and then in the Australian context is to look at, well, what are the sources of rights? Now, you're probably familiar with this, so I'm going to move through them fairly quickly and then raise some particular issues in the context of the topic of rights being taken away. So one source of rights is through entrenchment, usually through constitutional mechanisms. One of the most common forms of entrenched rights are Bill of Rights documents, Bill of Rights formulations. The other source of rights is through legislation, ordinary legislation. So there might be human rights mechanisms. So in Australia, for example, there are a series of anti-discrimination laws, the Racial Discrimination Act 1975, the Disability Discrimination Act 1992, and there are others as well. The issue with legislation, however, is the legislation is only as good as its drafting, for a start, and legislation, of course, can be amended and can in fact be repealed. So legislation in many cases has limited security. And of course, we know in the Australian context with state federalist split in law, we know that where state legislation is inconsistent with federal legislation, that legislation also can be overturned. And an example of that would be, you may recall several years ago, the Australian Capital Territory introduced marriage equality legislation, which was subsequently overturned by the federal parliament. Okay. The third area of sources of rights, of course, is case law, but particularly in Australia, in the absence of a parliamentary legislative Bill of Rights, or indeed a constitutionally entrenched Bill of Rights, case law has performed a significant role in being a source of human rights law. Particularly in the 1980s and the early 1990s, when the High Court of Australia, in a number of cases, was able to interpret in the Constitution a number of implied rights within the Constitution. Now, what we've been talking about up until now is three sources of law, entrenched sources, as I said, through the Bill of Rights, usually within a constitutional framework, legislation and case law. They're all domestic sources. We have, however, two other sources that are also relevant, and they are international instruments, treaties, declarations, conventions, which I'll talk about in a minute. We also have customary law, which is kind of sounds a bit free-floating, but I guess customary law refers to some of those kind of international norms that are present. And there are various, there's a various hierarchy of international customary law. Jus cogens, for example, probably would be at the top, which refers to compelling law that actually creates international norms, that even for member states that don't sign up, for example, to various treaties and declarations, they aren't able to have those norms derogated. In other words, they apply to them as well. Okay, well, let's move on to this. In the Australian context, you know, as I said to you, really recourse to rights has been through the state anti-discrimination legislation and through federal anti-discrimination legislation primarily, and the creation of some implied rights through case law. The reality is in Australia is, because we don't have a Bill of Rights, that we really have to exhaust domestic remedies in international law. Okay, so what are the issues there? In Australia, one is that no entrenchment. That's a huge issue, and there are some people who criticise the notion of entrenched Bill of Rights. There's been several debates over the years about whether Australia should have a Bill of Rights. Some argue that in fact a Bill of Rights would promote judicial activism. There's a strong view in Australian constitutional law of the notion of parliamentary sovereignty, that Parliament is elected by the people and therefore Parliament should take the primary role in human rights lawmaking. That aside, I think the other issue that we have in Australia in terms of rights being taken away, in terms of recourse to remedies, is we don't, unlike many other countries, have recourse to regional tribunals or regional treaties. Parliamentary intervention is something that certainly over the last 20 years into human rights legislation and decisions of the Human Rights Commission and the Federal Court, we've consistently seen Parliament come in and not only dispute the decisions of courts, but actually introduce legislation to remove the effect of case law. I guess the other critical aspect that many people who aren't associated with law may be unfamiliar with is in Australia is whilst governments go around and sign treaties, under our constitutional system, treaties are non-self-executing. So you can sign all the treaties till the cows come home, but the reality is, unless those treaties are introduced into introduced into Australian law by way of specific legislation that indicates that this legislation has been developed to introduce the effects of that treaty in Australia, those treaties really don't have much effect. Okay. So I guess one of the other big areas in terms of rights being taken away, and certainly from my own experience, not just working in Australia, but also working within the context of disability rights in Sri Lanka, is that you can have various human rights protections and frameworks within legislation. Lovely pieces of paper, you can sit there and study them and have a look at them, but you know, what some countries do is that they meet the requirements of various conventions to introduce domestic legislation, but there is no capacity either within that legislation or within the terms of political will to actually operationalise, to actually implement and give effect to those rights. So that's certainly a really big issue in Sri Lanka. Charles Epp, who's and I really recommend you to read his work. He's a political theorist, but he's looked at, I guess, what are the support structures that are needed to for legal mobilisation to actually give effect and I guess to operationalise and to breathe life into human rights laws. He talks about the necessity to firstly have an educated legal community. So I think that's really important in terms of the development of proactive jurisprudence and good legal analysis in case law. We saw that certainly in the area of Mabo, where the Mabo decision, where there was an educated legal community in the shape of the High Court in that decision, who referred to research and studies and testimonies to develop jurisprudence in that area. We might want to ask ourselves is how well is the current judiciary equipped in the area of disability jurisprudence to actually look at the operation of social exclusion in the lives of people with disability and to look at the practices of ableism. The second area he talks about is legal mobilisation, and that is looking at government, non-government bodies, as well as law reform bodies engaging in that process of legal mobilisation. looking at test cases. For example, with the Canadian Charter of Rights, certainly in the early days when that charter came off the ground, there were a number of test cases run by minority groups to test the limits and parameters of that. So rights can in many ways be taken away by rights, in fact, not even coming into existence and being operationalised. The third area he talks about is rights consciousness, and we know that, and it's taken a long time since, given that the Disability Discrimination Act had been in place since 1992. We're finding now, certainly the Human Rights Commission has indicated that the largest category of complaints to the Commission, it finally is now in the area of disability. But we actually need to have some consciousness about how we can use existing and test existing disability laws. Of course, the final area that EP talks about is having resources and financing to enable rights in the first place. I think the other area where we've got examples here in terms of rights being taken away is in the contemporary reality. We only need to look at 3 large Western nations. We've got the current case in the US with the Donald Trump regime overturning, or at least threatening to overturn, Obamacare. We also have the signal that there is the famous abortion case, Roe versus Wade, potentially will be overturned. So there's a sense that whilst these cases or programs or legislation shape the cultural environment, they aren't sacrosanct. They can easily be overturned by a change in government and a change in the body politic. In Australia, a couple of weeks ago, Tony Abbott talked about the desire, you could read threat, to actually shut down and repeal the legislation of the Human Rights Commission. We've seen examples in the last 10 years where the government, the Conservative government, has been unhappy with a number of High Court cases regarding refugees and immigration law, and have also introduced legislation to severely limit the impact of appealing the decisions of the refugee tribunal. In the United Kingdom, where I currently live, we've got the Conservative Prime Minister Theresa May, as part of the Brexit discussions, talking about moving away from the European Court of Human Rights so that the UK is freed up to make its own decisions about child immigration law. So some of the issues to think about in terms of rights being taken away, I guess, concern what is the basis of human rights? Is it based on formal equality, which very much supports a system of individual rights? And the human rights system in many ways has been structured around individual civil and political rights. Or do we look at more important questions about, well, what is the nature of injustice? What are the causes of injustice? What are the causes of poverty and powerlessness? And then move more to a model of substantive equality. In other words, looking at what is needed to redistribute resources and programs to create greater levels of equality. I guess one of the really big issues then is, what is human rights law's investment in individual rights? Well, some people would argue, in fact, human rights law is not about the rights of man, but is really about protecting the individual from the intervention of the state. We've seen a move, certainly over the last 30 years, of a paradigm shift away from concern with social and economic rights, social and economic inequality, towards an individual rights quote. Now, I just wanted to actually read you just to show that it's not just governments that have got an investment in this turn away from looking at civil and political rights. International organisation Human Rights Watch, for example, one of their executive director was quoted as saying that, while civil and political rights have to mean exactly the same thing in every place in the world, social and economic rights will be applied differently by one country with extensive resources and one that is very poor. And therefore, trawling cannot be considered as rights. Okay, so that's an interesting statement. Another CEO of Médecins Sans Frontières, again often viewed as a very progressive organisation, also said that economic and social advances and progress are very well, but they're not rights. So I think, you get various views on this. In fact, some theorists like Hayek argue that, if you really are pursuing social and economic rights, that couldn't happen without actually destroying the liberal order and transforming society into a totalitarian organisation. Now, I'm mindful that I've kind of gone over a bit of time here, so I just want to kind of wrap up by saying, well, what are the prospects and problems here? I think we need to be vigilant. We need to be careful as activists about not putting our social change strategies into one basket. In other words, just a human rights framework. There has to be other modalities of social change. Human rights programs and mechanisms can be educative and can involve consciousness raising, so that people, for example, who've been dispossessed and marginalised can be aware of what kinds of inherent rights that they have access to. Human rights regimes can be a form of embarrassment, although I must say under the current Trump reality, one would suggest that embarrassment now has a limited shelf life. Human rights can create international norm standard setting. I guess the converse of that is human rights regimes can be a form of legal imperialism that doesn't necessarily recognise cultural and political differences. I think the important thing to remember is when we're looking at human rights regimes, we need to have the other part of the equation. Human rights does not necessarily explain the why of subordination, why marginality happens. So we need to continue theorising that. And that will happen, I think, through encouraging, for example, the promotion of social and collective rights within and more analysis within that area. We could argue that a Bill of Rights are also really important so that rights don't get taken away and can be entrenched irrespective of government. One thing about a Bill of Rights that some commentators have argued, in fact, that in countries where Bill of Rights have actually existed, groups have tended to go it alone. So we've seen silos of legal action and legal activism, whereas where countries have had to resort to legislation that is not protected or entrenched, generally what's happened is there's been a building of coalitions. Well, look, I've covered a range of areas in very, very broadly, but I think, and somewhat unsatisfactorily to some extent, but hopefully some of the things that I've mentioned today will be useful for you. When I upload this video, I will also put some links to some interesting papers that are worth consulting to, so that you can continue your discussions and deliberations. Thanks very much.